All right, the recording is started. So good morning, everybody. To get started on this remote meeting, I want to go over a couple logistics as usual. As I noted, the meeting is being recorded. We'll post that to the Office of Open Government website. Throughout the meeting, I'd ask advisory group members to mute themselves unless you wish to speak to keep down the background noise. I don't know if we have any members of the public listening in today, but we don't have a provision for comments by members of the public. It's just available for listening. And if something goes wrong with the technology here today, I apologize, and we'll just have to end the meeting if I can't figure out a fairly quick technical solution. So with that, let me turn to just get a roll call of the advisory group members that are on the meeting, and then any or visiting attendees from different offices. So starting off down the list is Donald Brayman on the call. All right, I don't see Don in the queue. Paul Butler. Let's see, Paul. Renata Cooper. Don't believe Renata's on. Helder Gill. Helder's not on. Laura Hankins.
Here.
That sounded enthusiastic. Thank you, Laura. Dave
Here and
Rosenthal.
happy to be here. So glad to not see everyone, but to not hear your voices either.
All right, Dave Rosenthal.
Here.
Great, excellent. And Kevin Whitfield.
I'm as well.
Great. Okay, and I think a few visiting attendees from some of the offices. Seema Gejwani.
Hi, good morning, everyone.
Good morning. Nishant Kirkatz.
Here, good morning.
Good morning. And Katya Seminova.
Hi, everyone.
All right, and CCRC staff is also on the call, Janu and others. Oh, and I believe Dawn has joined us as well. So
And Ilana's here too.
Hey, sorry I was late.
No worries. And I'm sorry, who else joined on?
Ilana Suttenberg. Hi.
Oh, yeah, sorry. Ilana, there's like a little space I had written down my sheet, and then you were next. So I would have caught it, but thank you. I apologize for not.
That's fine.
I mentioned you. All right. Okay. So good. Just a couple announcements. It may end up being another very short meeting. We'll see. But on announcements, first, as I emailed you all earlier this week, one of our staff members, Gabrielle Green, who joined us earlier this year, resigned from her position in August, just a couple weeks ago. And we'll miss her, but rather for an attorney to fill the vacancy, the agency is conducting a search for a social scientist, someone who can help, particularly with review of social science literature that's relevant to our recommendations and kind of future work, and also to help with data analysis. And yeah, so we're very identify applicants. We would love to get somebody started in October, but that's a short timeline, so we need your help. So if you could forward to any of your networks, anybody, any individuals you know or organizations, the job vacancy that I sent via email earlier this week, I very much appreciate it. And again, we hope to move very quickly on that hiring, and, but also very important to get somebody who's well suited. Second announcement, in terms of workflow, I wanted you to know that so our next meeting is October 7th. And our plan is to, before then, it'll probably be around the end of this month of September, maybe first couple days into October. We do plan to issue a new batch of reports. This will be recommendations for a smattering of offenses, new offenses that we haven't previously revised. And also, we hope most or all the remaining general defenses that we plan to propose for codifying. So self-defense being front and center, but several others as well. And so that will be up for, hopefully be circulated and up for discussion, excuse me, at the October meeting. I expect everybody will have, at least a month, but probably more like around 6 weeks for written comments on that material. And meanwhile, staff is continuing to also work on a kind of a comprehensive, again, up across the board update to recommendations that will address all the comments we receive from you. And we're aiming to release that kind of big across the board update around the new year. So that's our main target, and hopefully we'll be able to meet that. As I mentioned at the last meeting, in this interim lull, I would, while you don't have kind of new material being in front of you for review, I'd really appreciate if any members or agencies want to take a step back and kind of review overall for the recommendations, where they stand, what is most important, what needs the most work, and contact me to set up a time to talk about that. I really appreciate hearing your kind of at end stage here, what your top level priorities and concerns are. Obviously we can't promise to address them favorably, but we will do our best to address them one way or another. And time is running out, right? We're given the council's change to our statute, we now have an extension to March 30th, but that's just 7 months from now. So we're definitely trying to focus in on remaining issues with what we have generated to try to get out some new work on general defenses and a few various offenses, but with an eye very much to finalizing the recommendations to go to the council and mayor early next year. So that's where we are staff-wise, and kind of what to expect in the coming month or so. And I believe that's it for all the announcements I had. So let me go ahead and turn to the agenda item, the only one on the agenda today, the advisory group memo number 38. This was circulated a while back, and I just wanted to flag a few things before opening up to questions. So big picture, the main difference of this memo 38 and its spreadsheet and the prior memo 28, which was about a year ago, is first and foremost the addition of data for 2019. And with that additional data, the spreadsheet and then in the PDF of that is attached to the memo, there are different breakouts for the years, right? So it predominantly focuses, and I think in many respects the most useful is the 10-year span covering 2010 to 2019. Okay, that's our largest one. We didn't include 2009 with that for a number of reasons. It's older. There's some more data or potential data issues, quality issues with 2009 data, and 10 is a good number. It's kind of easier to infer, what yearly averages are and kind of break that out. So that's the largest grouping. but there are also further breakouts, including one for just 2019 data. And the other new piece in the memo 38 is we try to do some additional analysis regarding consecutive and concurrent sentencing. And I think I mentioned this before, but you know, it's limited what we can infer from that. One major hitch that we encountered and kind of grappled with some of the court staff about how to proceed was that, you know, the court has a quality assurance process that is automated to kind of flag problems after court records are updated with the disposition. And, you know, there's like a 72-hour period after imposition sentence that, you know, there's that window, and this kind of the court's own kind of automated quality assurance does its best to, again, catch any kind of straight up clerical errors. That analysis does not include review of blanks in consecutive concurrent sentencing. So normally that is a field that you know, shows up for clerks to enter the sentencing information, but if it is left blank, it is either through a clerical error or deliberately, it is interpreted by the court as being a consecutive sentence. And so we you know, had to go back and kind of rework some of our analyses to include that assumption. As a data or record keeping matter, is as per law, right? Like if the judge is silent, that is also as a matter of law construed as a consecutive sentence under the Title 23, whatever it is, 101 provision. So there's that kink in there. Some other just straight up data quality issues with consecutive concurrent sentencing. They're detailed further in the report in the memo from our contractor, who kind of describes, you know, how these kinds of relationships, it's just very complex how they're set up, particularly when there are multiple judges in a case, or in some sense, or in some instances, references to consecutive concurrent sentencing between cases. There's just a lot of assumptions that had to be made because of incomplete, or in some instances contradictory data about consecutive concurrent sentencing. We did our best to sort through that, working with the contractor. The court kind of reviewed what we did. We tried to adjust our analysis to what they asked us to do, and you know, they saw a copy of what you received. So it's the best we can kind of do, but there are a lot of caveats, I would say, still to keep in mind on consecutive concurrent sentencing. The good news is we may be able to resolve some of that going forward. We have requested court data for not as this in Memo 38 and our prior Memo 28 both took kind of first in time sentencing dispositions. So what was kind of first recorded by the court for a sentence, but we've requested a couple other later in time data points. So one that would look at the 72 hour after initial imposition, and that will hopefully give us a chance to weed out some of the, again, straight clerical errors that are caught by the court's quality assurance process, as well as a data slice that looks at the last in time entry for the disposition. Now, there are some pros and cons to doing first in time versus last in time versus the 72-hour mark. We don't know for sure how significant these data slices will be. but changes based on appeals, some other changes in disposition, sealing could affect what appears and how it appears at a later point in time. So we're just going to do our best to take these different slices, and we'll see how much variation there is. I do hope, though, that some of the later in time sentencing will take care of what appear to be straight up clerical errors, right? Of what otherwise appear to be illegal sentences that were corrected, and hopefully in a timely manner, but still appear and kind of can skew the data that is in the first in time data set that was used for what you have before you. All right, so I hope that isn't too in the weeds, but I'm also happy to go into the weeds. So let me kind of open this up again. I am not myself a data scientist. Dawn on the phone is probably the closest I think we might have in this group to a person in that zone, but this data set is very complicated. Again, our contractor is has a PhD from Princeton, had worked with this particular data for years from the court, and still encountered a number of challenges. So it's tricky stuff. I'll try to do the best I can to answer any questions about the details, but I may also just have to listen, note it, and confer with our contractor to then get back to you all at a later date with an answer. But yeah, I know you all have seen, again, some numbers similar to this before from our prior, the statistics in Memo 28, but does anybody have questions you all want to raise about anything you saw in Memo 38?
This is Ilana. I have two questions that you have probably already answered or that are in some disclaimers about the data somewhere that I'm just not aware of. First question, if it's an attempt, is it listed as the completed offense? Like if we charge an attempt?
Well, yes. So attempts are included in here, both, and there are some columns again. So one, if you're looking at the spreadsheet, there are a number of hidden columns because otherwise I was trying to pick out, and highlight the most important. But if you select columns, right-click. If you're at your computer to unhide, you'll see other things. And some of the breakouts include breakouts by attempt versus non-attempt. But those splits and attempts to kind of break out the data still, any conviction, even if it was an attempt, will show up in the row under that citation, that micro citation. The finest grain unit we have in column A is what we call the micro citation, and these are essentially the court codes that were used, right? And they don't distinguish, so it's by the citation, not by whether it was an attempt or a solicitation, or solicitation would be separate, but it doesn't say, for instance, conspiracy, right? Those aren't distinguished. We have no way, unless the separate little flag for a particular charge or marks it as being an attempt to tell. So does that hopefully address your question? So yeah, attempts are in there, and some of these columns are going to break that out in a way that you might find useful. Yeah.
And my second question, in terms of when there's multiple charges, if you have an assault and a threat, does it list them under both charges? Would you get one assault and one threat, or is it just the lead charge? Once again, you probably already answered that question and I just forget.
No, great. It's a good question, right? So it will list both separately. So, right, if in a case the charges brought a simple assault and a threat of bodily harm, you're going to see a charge number for both. Obviously, maybe there aren't convictions for both, So the conviction data you see, you know, might not have anything there. But yes, this is broken out by charge, not by case.
Got it. So if you have the assault and the threats, then and you're just plead to an assault or something, then it would just lift a conviction for the assault and no conviction for the threats.
That's right. If that was dropped, or yes, for any reason after initial charging, it would just, yes, you would see nothing then for the threats in that hypothetical.
Got it. Thank you.
Yeah. And I would note too that like this is a big difference between the data here and any comparison to you know, a lot of the statistics that are reported out at a national level, or even from MPD, right? So often the lead charge, right, is kind of all that is captured in statistics. You know, one of the documents I flagged before and I've sent to y'all, but I think is very interesting and informative is the Bureau of Justice Statistics, again, did this study on state time served in state prisons. So it's looking at the state level at, again, kind of actual time served before release. And so it gives kind of, goes to the very end to kind of get a sense of how parole's effectively, you know, changing sentences and in a lot of jurisdictions. That document, which previously sent, again, it's working off of the lead charges only. And that's, again, very typical for a lot of the analyses that you see, particularly by Bureau of Justice Statistics, BJS, but also other kind of state, even, you know, MPD. So it is kind of unique about this data set that it's showing everything. And again, we were trying, and we will continue to try to look a little bit deeper at not just like, you know, the multiple charges, but also to understand how and where consecutive sentencing is working, because you know, obviously there are dramatically different effects on the person's sentence if they run consecutively, and while there are some you know, effects of having concurrent sentences, it's still not additional time. So our data should allow us to do that. Again, we've just hit a lot of kind of snag in the data to do that analysis well, because often the data simply isn't complete. It gets very complex when, again, 8 charges and the way, you know, does charge 1 run consecutive or concurrent to charge 7, to 7 to 3, and often we find errors in these relationships. Again, those were kind of explained a little bit more in the contractor's report. Yeah. Other questions from anybody?
Yeah, Rich, this is Dave. I may need to have a special session because I'm not sure there's a reason I went to law school as opposed to going into statistics. And so I'm not sure that I am understanding, interpreting correctly. So offline, I'd appreciate it if I could speak with somebody or some group of people that helps me understand this. But one question that I had, there are in the Appendix D in the memo, there are some places where there are like 47.1%, you know, to that kind of degree. But then there are a lot of that say at least 75%. I don't think I saw any at least 50% or anything else. And I was wondering what was special about that designation.
Yeah, you bet. So that is a strange thing. We do have, you'll see at least 75%. At times you'll see, it won't be written out in words, but you'll see the like little greater than, less than sign for less than 50%, less than 75. So what's happening there is we did the best we could. Court, we got this data with a data use agreement that has kind of a standard provision that is intended to protect privacy rights and being able to understand individual information. Now, whether that, a lot could be said about whether that is appropriate. This is all, in the public record. One could go and individually pull this from the court website, or one could have serious data skills and just run a program to pull all of this off of their data site. But regardless, they have been unwilling, and so part of the court has been unwilling to provide kind of allow us to report out in too granular a detail. When there's a small number of charges, we can't kind of we can't say too specifically, for instance, the number that were guilty pleas, because, if it's a very small number of charges and the percentage, it would allow you to infer, for instance, maybe there was only one charge, and it was. So
that was the cell suppression under.
Yeah, so
something like that, right?
That's right. So there's a straight up cell suppression provision in our data use agreement, which is a fairly standard thing that the court uses. And again, it prevents reporting a number under 20. Now, construing how to operationalize that, like obviously there are some places where a number under 20 doesn't actually reveal information, and other places it does. So we've done our best to report as much as we can to give a zone, as it were, where we can. So that's what you're seeing, this like at least 75%, because taking that piece of data and putting it with, for instance, we report the number of charges, that might lead you to be able to infer precisely something that would be a number under 20. So we've had to be careful at times. Now, this is our best attempt. We ran this by the court. They've seen this. They were okay with it. But that's why we've at times had to be approximate. And yet for other rows, you'll see more precise, right? Down to, like you said, the decimal point on the percentage. And that's because those are charges where there were large number, we're just dealing with larger numbers. And so saying 44.2% of the 357 charges for such and such, that still doesn't kind of cross the line as to where that under 20 DUA restricts us.
Got it.
So it's a strange artifact. Again, we're trying to do the best we can to report this out. I wish, that we could be precise on all of this. And, we're limited. So.
Thank you.
Yep. And other questions, and I guess I would say too, I am definitely, if you all have questions, you want to contact us offline, great. I may not be able to, while I've worked with the contractor and try to do the best we can by this, I may not myself be able to answer some questions. A couple of things I will just kind of mention to caveats as you review the work. So again, in the spreadsheet, both in the PDF form, the printouts that only have certain columns, or the Excel spreadsheet, which has many columns, most of which are hidden and you can unhide and look, they're organized some by citation, right, in column A, some by the number of convictions, some by the severity of sentence at the 95th quintile, for instance. Those, I would suggest, while you might want to dip a little bit into the number of convictions for the quintile, beware. So whenever these sheets are not organized by citation, what happens is you'll see a row and it'll say something like, let's see if I can find an example, obstruction sheets. And you may think that is, and it'll show the right citation, and you might think that is what those are the numbers for all obstruction of justice charges. Unfortunately, again, the codes that are used, the level of detail on the citations really varies for different offenses. So there might actually be, the most egregious is probably like carrying a dangerous weapon. I think there are probably 14 different court codes. And so there are 14 rows, or approximately, I don't know, there might be 20 but a bunch for carrying dangerous weapon. Now, one of these is the biggest, kind of a catch-all or an apparent catch-all that, has 3,100 charges. And that's where most, the code that's being used for most of these cases. There are some others that are, under 20 or, and they're each in their own row. When you have the sheet organized by citation, they will all be right next to each other, right? So all of these, look at column A, you're going to see like, okay, for carrying a dangerous weapon, 4504A1, 450, and next row, 4504A1-X, 4504A1-X, but it has a different name that we, again, brought over from the court. It's perhaps important, perhaps being accurately reported, and then so on, -Y. These different court codes, which are being used, at some point, they were trying to make a finer granular thing. Maybe it was the difference of, a pistol versus a long gun versus prior conviction versus some other part of that citation at 4404A1. Sometimes you can tell by reading the name, sometimes you can't. But rather than smush together and like merge, we left that granularity in there. And that's all well and good when you are looking at things by, again, ordered by citation, and you can see side by side, oh, right, there's a main category for carrying a dangerous weapon that has 3,100 charges. But there's another one right next to it that has 660, and for my purposes, I'm just concerned about 4504A1, whatever the more granular thing, and you will be able to see that and then kind of track it through the spreadsheet when it's organized by citation. When you, however, do sorting by, the 95th quantile or the number of convictions, then you lose track of those other rows. Suddenly, by the number of convictions, that one row, the one code that was used the most, obviously that's going to be, at the top with a very high number. Some of these others, which for your purposes, hey, it's still a 4504A1 conviction. It seems to have some other weird code, and like maybe the name we get from the court is a little different, maybe not, but that disappears. It goes way down on the list. And so if you're only looking at one row when it's not ordered by citation, you might be deceived because it may be that other rows have that same citation going to that same section or even that same subsection, but are listed separately. So apologize for that confusion. That is been very confusing to us, and how it changes how you can use the data. And sometimes, it's helpful to know, for instance, with certain, controlled substance offenses, kind of really breaking it down, because sometimes there's a lot lumped into a particular statutory section, and it's helpful to know, well, which particular phrase in there, which of the offense is being spoken about. Other places, it's just unclear. Often what we see is there will be a row or a category that generally refers to the statute or a statutory section, and then other rows that refer to particular parts of it. And we can't tell what's going on in that relationship when one of the rows is just for citing to the section. We don't know if over time the court has been consistent in this. We, obviously court clerks who are the ones kind of recording this are not, machines that can, kind of normally do this, and different training, different practices over time, 10-year span. So yeah, just when you're sorting, if you're looking for all of something, check that there aren't nearby citations when it's ordered by citations. That would be my tip. Let me think if there's any other kind of big kind of or useful caveats when you're searching this. I guess the other thing I'd say is, look, we have these quantiles here, and we included a tab to look at the top number, right? That sorts it that way. On the spreadsheet, obviously, you can sort it however you would like. This was just trying to be a useful mechanism to be able to quickly go to that tab. And we do have columns that kind of say what for instance, the 5th percentile for a sentence for a particular charge was. I would caution that for charges and offenses where there are very few, prosecutions, let alone convictions, be very careful, right? The kind of law of small numbers here, that one, not just that an actual sentence occurred and there were only 5 for this particular offense over the 10-year period. It's very easy to see how one outlier might kind of really skew these numbers. But it's also possible a single error, a clerical error, which again, we do believe there are a number in here because this was the first in time. It didn't go through the quality assurance process. One error, and often what we see seems to be for instance, treating months as days. So normally this is the numbers are put in as months, but somebody instead thinks days. You'll see, 1 month becomes 30 days, and so 1 becomes 30, and that suddenly, might really skew misdemeanor, right? And the sentencing that you see for that. So again, when it's low numbers for either the number of charges or convictions, please be, particularly wary of kind of the again, especially the kind of the highs and lows in terms of what it says the sentences were. They may be off. We again hope to get an updated data set that'll reduce some of this and reduce some of the effect on these quantile numbers. But right now, we worry that that's something that makes these numbers off, maybe higher, maybe lower. Any other questions I can address with the group? All right. Well, in that case, we don't have anything else on the agenda. So if there's no final comments, I'll let everybody go. And we'll call it a short meeting. The next meeting scheduled for Wednesday, October 7th, usual time at 10 a.m. And like I say, in the interim, you will receive we plan to get out to you some new reports with recommendations for general defenses, including self-defense, and a number of kind of various offenses as well. So thank you all. I hope everybody's doing all right, and don't hesitate to reach out to me if you have other questions. So with that, we'll call it a meeting. Thank you all.
Bye, thanks.
Thank you.
Thank you.
Everyone.
Thanks, Richard.
Bye.